open yet. Do you have an appearance that you will be filing with the clerk of the court?
Yes, Your Honor.
All right, and then we also have from the Attorney General's office, Mr. Oskowitz, and we are here today for the arraignment. And Mr. Chamberlain, have you and your client received a copy of the indictment?
We have, Your Honor. I've gone over the charges with Mr. Lyon and the penalties, and we waive formal reading of it.
All right, and how will your client be pleading today?
Not guilty to all counts.
And at this time, I am going to go through, I know you're waiving a formal reading of the indictment, but I am going to go through the counts and the maximum penalty just for the record. And at this time, I want to inform the defendant that pursuant to the indictment, sir, you are charging count 1 with involuntary manslaughter. That's a felony, carries a maximum penalty of up to 15 years and or $7,500 fine. Count 2, also involuntary manslaughter, also a felony, carries a maximum penalty of up to 15 years and or $7,500 fine. Count 3, involuntary manslaughter, 15-year felony, $7,500 fine. Count 4, involuntary manslaughter, maximum penalty of up to 15 years and or $7,500 fine. Count 5, involuntary manslaughter, felony with maximum penalty of up to 15 years and or $7,500 fine. Count 6, involuntary manslaughter, maximum penalty of up to 15 years on that felony and or $7,500 fine. Count 7, involuntary manslaughter, felony with a maximum penalty of up to 15 years and or $7,500 fine. Count 8, involuntary manslaughter, felony with a maximum penalty of up to 15 years and or $7,500 fine. And count 9, involuntary manslaughter, felony, maximum penalty 15 years and or $7,500 fine. And count 10, willful neglect of duty in violation of the Michigan Public Health Code. And it does not state on the indictment the maximum penalty, and that is MCL 750.478, which is a misdemeanor with a maximum penalty of up to 1 year and or $1,000 fine. And the court will accept a not guilty plea to all counts. And counsel, you may be heard on bond.
Your Honor, on behalf of Mr. Lyon, we respectfully request that the court order a personal recognizance bond. Before the court is a 52-year-old gentleman who was born and raised in Michigan. He's lived here his entire life with the exception of 4 years when he lived in the state of Connecticut going to college. Following college, he returned immediately to the state, took employment with state government, where he was employed until 2018. His first job was with the Department of Attorney General and had a career from one of the lowest positions in state government to the director of the largest state agency in the state. He currently resides in Marshall, where he's resided with his wife and children for 15 years. His children remain in the state, one in college, but in Michigan. And as the court is aware, Mr. Lyon was charged in 2017 in a matter that was before one of your colleagues, Judge Goggins, at which time a bond was set. Mr. Lyon, that matter continued into circuit court for a period of 2 years. And during that period of time, while on bond, he didn't violate a single condition of bond. He cooperated in his defense, met every single meeting with counsel. Pardon me. In fact, Your Honor, we've represented him continuously for 5 years, during which time there have been investigations. And Mr. Lyon has made every meeting with counsel and has taken an active interest in his case, has never left the state without, permission while on bond. Moreover, Your Honor, Mr. Lyon, during this period of time, was a party to extensive civil litigation stemming from some of these same claims. He was active in his own defense with counsel, cooperated completely, was represented by the Department of Attorney General, which successfully got him dismissed from the civil litigation. We respectfully request that under the circumstances, a personal recognizance bond is appropriate. Thank you, Your Honor.
Thank you. And Mr. Oskowitz, would you like to be heard on that issue?
Yes, just briefly, Your Honor. The people are aware, as well as the court, of the intense publicity of this case, as well as the challenges facing the criminal justice system due to the ongoing pandemic. So mindful of that, Your Honor, we're asking that you set a reasonable bond pursuant to MCR 6.106. However, I do not believe a personal recognizance bond is appropriate in this case, Your Honor. At the very minimum, under 106B, Your Honor, I ask that the defendant be ordered to appear at all court dates, to not leave the state without permission, and not commit any crime while on bond. However, Your Honor, due to the seriousness of these offenses, people are asking for a $200,000 cash surety bond because he is charged with essentially nine homicide offenses, Your Honor. We are aware of his lack of criminal record, his history of appearing in the prior case, Your Honor, but these charges are much more serious than his prior case. Based upon that, Your Honor, we ask that that bond be ordered. In addition, Your Honor, we ask that the defendant surrender his passport if he should make bond, and he have no contact with the other defendants who are charged in this matter. I can put those names on the record if you'd like. Due to the pandemic, Your Honor, if Your Honor is not inclined to issue a cash surety bond, we at least, at the minimum, ask for a unsecured appearance bond, large one. However, we believe that personal recognizance bond is inappropriate in this case. Thank you.
Thank you. And then Mr. Chamberlain, any brief response?
A brief response, Your Honor, as to the condition precluding him from conferring with other people who are charged. We respectfully submit that's a violation of his right to defend himself in this action, and ask that that not be imposed. Again, we ask that, for a personal recognizance bond given his history of appearance.
Thank you, counsel. At this time, the court will. I agree with Mr. Oskowitz due to the serious nature of the charges. I know, Mr. Chamberlain, you cited to prior case and that your client complied with all terms and conditions. One of the aspects of MCR 6.106, the court does get to consider the serious nature of the allegations, and with 9 counts of involuntary manslaughter, court does take that very seriously. And at this time, I will grant the request of the people. I will set a $200,000 cash surety bond, and I will also order that if Mr. Lyon does have a passport, that be surrendered. And then terms and conditions of the pretrial release will also include he is required to appear for any court dates. I will note that a lot of our court dates are conducted via Zoom, and those still require appearance. Those are still court dates. It might not feel like a court date since you can Zoom in from your living room. However, those are court dates, and I expect Mr. Lyon to participate in every court date. And if we are doing it via Zoom, that he Zoom in with counsel. As far as the other conditions, he cannot leave the state of Michigan without permission of the court, cannot commit any crimes while on release, and he is required to immediately notify the court in writing of any change of address or telephone number while he is out, if he is able to be released on bond. As it relates to no contact with other defendants, Mr. Oskowitz, there was nothing that was specific as far as concerns that were identified. I'm not going to grant that condition at this time. However, it would be preserved. If you want to elaborate on that, file a motion in regards to that. But at this time, that request is being denied. And for purposes of today, until this case gets assigned to a judge, because this is just the arraignment, I'm going to schedule the matter for a pretrial. And that is going to be on Thursday, the calendar, February 18th at 3 p.m. At this time, that will be conducted via Zoom. And anything further for the record on behalf of the defendant, Mr. Chamberlain?
No, Your Honor, thank you.
On behalf of the people, Mr. Oskowitz?
No, Your Honor, thank you.
All right, and then I do have the pretrial release form here. And as soon as I have a moment to complete it, with the conditions that have been stated on the record, we will send that over to the jail via email.